What's up, everybody? What's up, everybody? Welcome to the live. Welcome to the live. Give me a like. Let me know you're here. Let the algorithm know we're here. Haven't been on live in a while. It's been a while, and I know consistency is the key to recognition here. So we might not have much, but I do want to do kind of more with my YouTube page. I want to do move away from lives and do pre-packaged videos. Like I want to do something about the appeal, the ruling, that kind of thing. But I think it's good to also get into the live, tap into everybody and say hi. If you're watching and so inclined, let me know where you're from in the comments and how everything is going. Again, we're here to talk about the ruling in Tory Lanez's appeal for his convictions and sentence for shooting Megan Thee Stallion. There was a order issued on Tuesday, and we've still got oral arguments in his main appeal set for Monday. But as my article explains, which you guys can find on legalaffairsandtrials.com, appellates are considered to have a constitutional right to oral argument in California. So it's really standard that they're not going to issue a ruling on his appeal until after oral argument, but that doesn't apply to his habeas petitions. So they were able to get that ruling out before oral argument. But the chance that they've already written their ruling on his main appeal is about 100%. That's how they do it. Before the judges sit down, all the cases they have on calendar on Monday, barring maybe a huge exception, they will have a written opinion circulating amongst themselves that they've talked about it, and they're not going to obviously finalize it until after oral argument. But one thing I've heard that I think the second district has started doing, some of the courts have started doing, the appellate courts, they've started actually giving the tentative ruling to parties ahead of time. I don't know if that's happened in this case, but it could have. So the idea is so the attorneys can go into oral argument on Monday and know what the issues are, what they need to address, that kind of thing. So let me see. This is the court's calendar. It should be online. I'm not sure how availability will be, but I've got a request in to stream it. They haven't responded to it yet, but I don't think the court gets a lot of requests like that. But they'll have it. You can see the date right here. It's the morning session, 9 a.m. They'll have it right there. But here, this is their that's Division 6. They don't have the actual calendar up for the 18th yet. But you can see how they do it. They've got the video here. This was their one that Division 4. This is Division 3. That's the one his court's in. But this is how it looks. This was the argument that they heard yesterday. They heard 4 cases yesterday. It took them an hour and a half, but you can see the different camera angles, the judges and everything. But yeah, we should be able to see that on Monday for Lanez's case. But if you guys go to my my article on legalaffairsandtrials.com, I've explained everything there about this order that just came out. I mean, the thing is, this is not really it's not really news. It's not a surprise at all. I mean, he just has no appealable issues. Like if you read his briefs and everything, you can just see in the very beginning when all this stuff was filed that all this stuff was just going to be dead on arrival. But especially with the court denying both habeas petitions, because they had consolidated the habeas petitions in with his appeal, and they were going to consider them all together. And I know his supporters online were hailing that as a big victory. And one problem with this is they're just using it as an avenue to harass a violent crime victim who's Meghann. I mean, that's all this is with this ongoing appeal stuff and everything they trumpet with it. And, the court accepting the petition or allowing him to amend something or something. It's all just insignificant ministerial things. And anyone who knows anything about the appellate courts can see that he has no issues at all. And then when you actually read his briefs. His briefs aren't like good. So, I mean, the idea that this is even news that his appeal is being rejected, I mean, it is just because it's such a high profile case and people are interested in it, but this is not surprising to anybody at all. And like I said, the chance that the court has already written its opinion about his main appeal is about 100%. It'll just be interesting to see how, what the argument actually is on Monday. And then after argument ends, how fast do they actually issue their final ruling? I wouldn't be surprised if it's that week, which would be an incredibly fast turnaround. But I mean, if there just aren't that many issues here. But it was a 4-page order on his writs. And remember, this is or not his writs, but his habeas petitions. And this was the stuff he was alleging was new evidence, like the statement from his driver who didn't testify. And then there was the claim, he had a lot of claims about DNA evidence in his habeas petition, and then also claims about new sentencing laws in his habeas petition. That was in the first one that was filed pretty shortly after he was sentenced. This was back in October 2023. And then, or maybe it was December 2023. Or he filed notice of appeal, and then he had one in February, and then I think October 2024. It was February 2024 and October 2024. But the second writ was about the supposed missing gun and not being able to do DNA testing on the gun. And then just a couple weeks ago, they requested permission to amend that petition to add the statement from the security guard who said he accompanied Kelsey to the trial and heard her say things about am I going to tell on myself? And that, she had fired the gun a couple times and Lanez had taken it away from her or something like that. They presented that as new evidence in a habeas petition. So this order on Tuesday, this 4-page order, rejects all of that. So his DNA argument is totally done. Both the idea that the driver's statement would matter or anything like that, all that's been finalized. And the big thing with his driver's statement was McDesian, who did the trial, his original trial lawyer, knew how he was going to testify and just chose not to call him. And Lanez's appellate attorney actually got an affidavit from the security guard, or excuse me, from McDesian for this new supplement just a few weeks ago, where he said that he shouldn't have used the word unfavorable to describe how the security guard might have testified, but it completely misses the point, because the point isn't whether Lanez's attorneys thought it was favorable or unfavorable. The point is they knew about it, and that's what makes it not new evidence. And McDesian's declaration actually just reiterates why it's not new evidence, because he actually states in the declaration that he chose not to call him because he thought it would be cumulative. So it was always just a given that would be rejected, and the court, this order rejects that, says that it's not acceptable as a habeas petition or new evidence, or anything like that. The DNA testing ruling, it was nice to see how short this was, because when you actually read his filings, I mean, they're just, the DNA stuff is practically nonsensical. And to spend a bunch of time trying to rehash and sum up the argument and then it's giving it way more time and justification than it needs, because it's just, these arguments just fall flat on their face to begin with. And that's obviously what the court recognizes here. But it says petitioner further contends that the expert testimony regarding DNA testing offered at petitioner's trial, petitioner is obviously Lanez, did not comply with industry accepted reporting standards. Petitioner fails to provide any reasonably available documentary evidence in support of this claim. Aside from the fact that petitioner is contending that his own DNA expert failed to provide industry accepted methodology, this issue could have been, but was not, raised on appeal in the context of an ineffective assistance of counsel. And this just kind of gets into Lanez's appellate attorney, Crystal Morgan. I mean, I'm sure she's a nice person. She doesn't know what she's doing. She doesn't have a lot of experience in the appellate courts, and this whole thing, how she went about the habeas petitions, everything is just a mess. But that's to say, it's not like if he had a really experienced appellate attorney, it would somehow advance these arguments more, because there just aren't really any issues that would ever lead to him being resentenced or getting a retrial or anything. And there's just a lot of confusion about everything because I saw somebody, one of his supporters was saying online that, this could lead to a new trial or, even his convictions being overturned. Like, don't be confused. Those are the same thing. Like, to get a new trial, his convictions would have to be overturned. But it's just not happening. I mean, I would encourage everyone to tune into oral argument on Monday because I think it could be educational just in terms of how the court views all this and the quality of the filings and the quality of the arguments. But the DNA stuff is dead on arrival. I mean, this wipes that all out because one issue in putting my article together is that there are so many filings. But if you go into legalaffairsandtrials.com, my website here, if you're a paid subscriber, I've got links to everything down here because he's got overall 4 main filings. He's got his first habeas petition. That was December 2023. Okay, that's the one about the driver's statement right here. And then he's got his main appellate opening brief right there. And then, his motion for relevant evidence, which is the Racial Justice Act stuff. This is the AG office stuff. Here's a second habeas petition about the supposed missing gun that's not missing. Here's his supplement, which is about Kelsey's security guard. And then I've got the AG responses here. So there's actually 5 documents to look at. So this order on Tuesday ends everything except the main appeal opening brief. And when you go into the main appeal opening brief, I mean, you can just keyword search DNA and see that all his DNA arguments were made in the habeas stuff. So that's all been wiped out. And his main arguments in the brief are that Hereford erred by telling him that if he testified, he would be that prosecutors could ask him about songs that he wrote about the shooting. And also they're arguing that Hereford erred when he allowed testimony and other evidence about Megan's emotional state. And the Instagram post. I think a lot of people who've been following the case have to know of the Instagram post, the Shade Room post about the case where Lanez's Instagram account responded to a comment about Kelsey being the shooter. And he said, that's not true. And that was admitted as evidence in trial. And part of his appeal is that was an error so much that the entire conviction should be overturned over it. So I don't think they're going to find that an error. But if they do find errors, that doesn't mean that his conviction is going to get overturned. They have to find that it was a reversible error by the judge. So it means the judge's decision, like the overall conviction judgment, can get reversed because the judge screwed up so bad and the trial was so prejudicial. And these issues that he raised just aren't enough to get him there. But like I said, they have not issued their final ruling publicly on the appeal because everybody has a right to oral argument, and there's oral argument on Monday. But I think the final ruling could be issued pretty quick after that. But we're going to hear a lot on Monday about the argument and just what the judges think about it. It'll be interesting to see how chatty they are. Sometimes they're not real chatty, but and a lot of the times when you see these arguments, they really play both sides of the fence. Like one side will get up and be peppered with questions, and you'll be like, "Oh wow, the justices really aren't feeling this." And then the other side will get up, and it'll kind of be the same thing. They're like playing devil's advocate, but I'm not so sure we're going to see that here because just his arguments are just. I mean, I told somebody he might have been. These briefs are so bad, he might have been better off having like AI do it or something. But they're just. It just doesn't get him there. But improper comments. The stuff about pizza motion. Improperly the creative expression thing, that's probably the most interesting part of his appeal. Is that's under a new law that changes the standard that judges are to use when they decide whether to use like musical lyrics or art as evidence against a criminal defendant. And they're saying that Hereford committed reversible error under that by telling Lanez that songs he wrote about the shooting he could be questioned about if he testified. And I I'm not sure that decision by Hereford could be found to be in violation of that, because remember, this new law doesn't outright ban the use of song lyrics. It just changes the weight and says judges need to put more weight onto the possibility that it could be prejudicial. So it's still possible for judges to say that that's fine evidence, and I think in this case we'll see that. One thing in the appeal, and this my article explains this. It's actually not a total loss for him. It doesn't shut all doors on him, because he had asked for information under the Racial Justice Act. He had alleged that the proceeding was biased against him, and that the prosecutor, somebody in the court proceeding, was motivated by racism. And then separately, he also asked for discovery to pursue that claim more, like information about race-related statistics, prosecutions, like stuff that he could use to show that he was unfairly targeted because of his race. And they rejected that, but they left the door open because there's a California Supreme Court case pending that relates to that. And depending on how the court rules, it might make it a little more lenient for people who are trying to make those requests. So they told him, depending on how that ruling goes, he could file another writ later on based on it. But if that happens, like, there's never been any real allegation that the prosecutors or the judge did anything like that. And not only do you need an allegation, you need actually like a trial record that shows something happened. And there's just nothing to support that. But that door is still open under this ruling. Like I said, it blatantly leaves the door open for him to file another petition seeking information like that. But guys, I mean, the idea that anything like that would ever lead to his convictions being overturned, no way. But that being said, I mean, the 4-page ruling is not a complete loss for him because of that. But it's a pretty big loss for him. I mean, and that's the thing. I have a small audience now, but I imagine I'll get some playback, and I'm going to cut this up into clips. But this is just an avenue of harassment for people online, and not even online. I saw that paparazzi approaching Klay Thompson and asking, what does he think about Tory coming home soon? I'm like, guys, Tory is not coming home soon. Like, that is not happening. His earliest parole date is, I think, September 2029. And that is not, we're not going to see anything. This appeal is not going to affect that. So I would just encourage everyone to kind of, hopefully the final ruling in his appeal kind of closes the door on some things. I'm afraid it won't, but it's a little delusional how so many of his supporters, I mean, even after this ruling that rejects his habeas petitions, are trying to hold out hope for Monday. And like I said, the chance that the appellate justices have already written a ruling rejecting his main appeal is about 100%. It's a question of, have they distributed to the attorneys as a tentative, or is it just amongst themselves? I don't know. I have no idea. We might find out on Monday. Sometimes they reference that stuff. They're like, oh, we got your tentative ruling or something like that. But we don't know. Sometimes you just don't know. You could watch the whole argument and not know that the justices already have a ruling written. But when I worked at the Daily Journal and I interviewed judges and appellate justices, or people who used to be research attorneys for appellate justices, mostly in Orange County, that's the process. I mean, on rare occasions they might, but usually there is a draft opinion that's been circulated amongst the judges before oral argument. So we will see. But again, thank you guys so much for tuning in. I'm trying to do more with my YouTube page. I got to get back to that murder case that Doug Weinstein was doing out of Georgia, which it's funny because, I mean, it's not funny. That case was horrifying, but there's so many more interesting trials going on in America, but that was televised. So, but that guy was a psychopath. I mean, of course the jury convicted him in like 40 minutes, but if you guys go to my TikTok page, I've got some clips up on that. And I was going to post a couple more, but I want to do more video stuff, pre-planned, pre-packaged video stuff about the articles that I write, and really get into the appellate rulings, because sometimes doing these, just talking on the fly like that doesn't always work, but we'll see. I plan to do more on Monday for oral argument, and I'll hopefully be able to get some clips up, but it kind of depends on what the court says. So thank you all for tuning in. I will see you guys later. Give me a like. Shout out to the playback crew. Stick around. Subscribe to my channel and also find me on Facebook and stuff. I'm trying to post more video stuff there and kind of package my written articles into videos. So we'll see how that goes. But thanks, guys.